All right, so the last class of wills that will be included on the midterm is what constitutes the will. We're going to be looking at various ancillary documents and pulling them in and making them part of the will. First, as part of review, make sure that you can identify the various sections of the will. You need to be able to identify the type of bequest, whether it be specific, general, demonstrative, or residual, and work with those provisions. Keep in mind there are also non-dispositive provisions that should not be boilerplate, should be analyzed as to whether or not they should be included. In terms of execution and safekeeping, make sure the execution ceremony is proper. Don't take the shortcuts. Remember Morris v. West. And you need to be able to at least communicate to your client the importance of having and locating the original will, whether or not you tell them to let the personal representative know where it's going to be. You mark it in your file. There's a stamp there. You might want to identify any conformed copies with where your client told you the original will be kept. All right, this section, which is the last section that will be covered on the midterm, deals with whether, what makes up the will. So if you have a will and a codicil, what makes up the will is both the will and the codicil. How, under integration, do we have all 5 pages of a 5-page will constitute the will when the formalities are only on the 5th page? Incorporation by reference is a 3-factor test in which you might incorporate a non-complying document as part of the will, as long as it's in existence, intent, and identification. There's a special UPC rule. And how do we allow things that change after we execute the will under facts of independent significance impact our will? How is that not violating our formality requirements? So those are the 4 concepts that we will cover in this last and final section. Well, a codicil must be executed with the same requirements of a will. There's no shortcut. It can cure defects of a will. For example, if you had a disinterested witness, if the disinterested witness rule, if you had an interested witness signing as a witness and beneficiary, you might be able to cure that by different witnesses on the codicil. Integration, again, formalities are on the last page. How do you make pages 1 through 5 part of the will? Take a look at the Constitutes case. That does a very good job at laying this out. A bar exam favorite is incorporation by reference, IBR, common law doctrine, although there are statutes. Look how many times it's been recently tested. Second, 3-part test. Intent. How are we going to know intent? What does the will say? The will says, I hereby pass my jewelry to the persons named in the letter found in my desk drawer. Existence. How do we know its existence? We look for dates. Identification. Give it a name so that the court with reasonable certainty can make sure they have the accurate document. The UPC comes up with a different rule, eliminating the existence requirement to the extent the writing is signed and describes with reasonable certainty the items. The key is that it can only be tangible personal property. So it can only be stuff. Can't be real estate, can't be money. But that is another test that should be examined if the incorporation by reference doctrine fails. We'll take a look at the Clark v. Greenhalgh case. Make sure you understand the estate plan. What are the requirements? This is an IBR case. This is Helen Nesmith's estate plan. And think about the codicil and the impact it had. What if no codicil? What would have happened? So keep that in mind. The 80 and the 280 codicils give life to the 79 notebook. The 79 notebook, in which there was an addition of the picture to Jenny, would not be effective but for the subsequent codicils. Facts of independent significance. All right. So, how do you look to things outside the will that actually control the will? And how is that not a formality flaw? How is that not changing the will with outside the formalities? Well, as long as those changes are occurring for independent reasons, some objective independent reasons, they will stand. Take a look at the problem and make sure you understand the key there is that title controls everything. Let's take a look at some hypotheticals. We'll take a look at these hypothetical. Number one, all of the money in my Legg Mason account to Aunt Barbara. Well, there's going to be changes in that Legg Mason account from the date of will execution to date of death. Those changes will stand because I'm moving money in and out of my Legg Mason account objectively, because that's what people do with Legg Mason accounts. That's what people do with brokerage accounts. So that one would be valid. What about two? All of the cash in my kitchen drawer to my sister Marcy. Well, that's not where people keep money and bequeath it. So the money going in and out, what is the objective, any other objective reason for keeping that much money in a kitchen drawer? Probably not. That one would be problematic. All the stocks and bonds found in my safe deposit box. Well, what is the purpose of a safe deposit box? It is for safekeeping. So why wouldn't that be sufficient? $1,000 to each of my employees. Well, I'm not going to stop running my business as of the date that I execute my will. I'm going to hire and fire people for my own independent reasons. And so that one would stand. What about 5? The rest and residue of my estate to the beneficiaries of my brother's will. Well, guess what? My brother can update his will. And that update will control my will, my residual bequest, because my brother is updating his will for independent reasons. And therefore, that provision will stand. So we'll take a look at these. Facts of independent significance is a little tough, but hang in there.